How do you prevent misrepresentation in a business immigration application? Hi, my name is Ka from Sinka Immigration. We have helped a lot of businesses and individuals to immigrate to Canada through the business immigration program. And today we're going to talk about how to fill out forms correctly and avoid making mistakes by accident when you apply to come to Canada. Now, making mistakes can cause really big problems, like having your application refused or not being allowed into Canada. By the end of this video, you will understand what you need to do to make sure you don't give wrong information when you apply to come to Canada. Now, remember, it's really important to be honest and give the right details when you apply for a business visa to Canada. Would you like to come to and live in Canada as a permanent resident? At Sinka Immigration, we can help. So, what does misrepresentation mean in Canadian immigration? First, let's grasp the concept of misrepresentation within the realm of immigration or visa application. So misrepresentation refers to the act of providing false or deceptive information when submitting an application to the immigration department. This encompasses hiding pertinent facts, presenting falsified documents, or making untrue statements in order to obtain approval for a visa. So often, applicants unintentionally misrepresent themselves due to a lack of comprehension of the questions asked. Sometimes, the immigration department employs highly specific legal terminology, which can easily lead to misunderstandings of statements and questions. However, even when these mistakes are not deliberate, they can still carry potential short and long-term repercussions for future immigration proceedings. So next point, prevent giving false information by completing your immigration forms accurately. As immigration consultants, we continually anticipate the immigration department to simplify these procedures, making them more accessible for everyone. However, until such changes are implemented, let's find a way to comprehend and respond to these complex and confusing questions accurately. Now, one common challenge applicants face is understanding and correctly answering questions regarding criminal history. Many struggle to differentiate between being charged with an offense and being on trial. It's crucial to recognize that IRCC isn't asking about innocence, but about pending charges. So even if not yet on trial, if you're under investigation and charged with an offense, the answer shall always be yes. For instance, in some countries, a DUI, which is drunk under influence, may result in only a fine, but it must still be declared as a conviction in your application. Applicants also often provide incorrect information regarding past refusals or orders to leave a country. Now, understanding the distinction between being refused admission and being ordered to leave is very important. Refusals can occur before entry, while orders to leave happen after entry. Both must be disclosed accurately, because failure to do so can lead to rejection based on non-disclosure. Now, for example, in some countries like New Zealand, overstaying a visa for more than 42 days categorize you as having been ordered to leave, even if you leave voluntarily. Another challenging question involves disclosing past detentions and also jail time, While it might be tempting to answer no if released or found innocent, it's important to choose yes and provide a detailed explanation. Transparency about any encounters with law enforcement, regardless of the outcome, is essential to avoid misinterpretations that could harm your application. In conclusion, it's crucial to carefully review your travel history and accurately disclose any relevant information in your application. We advise thorough caution and compliance with immigration regulations of any countries visited in the past. Here is a true example of giving wrong information in Canadian immigration. So while filling out information application forms, clients often overlook the travel history, thinking it's not important. But that is a really, really big mistake. Now, let me share a story about an investor who wanted to move to Canada permanently, but got rejected because he didn't give the right information. Now, during his application process, Mr. Hu, a 33-year-old from Bangladesh, applying as an investor, faced charges of not being admissible due to leaving out and giving wrong details about his past studies, where he lived, and where he worked. The decision was made by the immigration program manager in Singapore on May 28, 2010, which led to a review in court. Hu's application, submitted in March 2010, didn't mention his time living and studying in the United States for over a year. Also, he didn't accurately say where he lived, studied, and worked. When asked about these missing informations by the Canadian Immigration Office in Singapore, Mr. Hu's advisors said that they thought the short time in the United States didn't need to be mentioned. But Mr. Hu said something different in a call with a visa officer on May 26, 2010, saying that he told his advisor everything and it was the mistake. The court looked at the case and found that Mr. Hu didn't mention going to school in the United States for 3 semesters, from November 1997 to December 1998. This was discovered when the visa officer checked the records about Mr. Hu's past visits to Canada while he was in the United States. Now, even though Mr. Hu said it was a mistake and blamed his advisor, the court agreed with the decision that he wasn't admissible. They said that the applicants must be honest and provide all needed information. They also said that Mr. Hu shall have mentioned his time in the United States and the differences in his addresses and work history. They rejected Mr. Hu's claim that he fixed the mistakes, showing that the differences only came up when his past visa applications were compared to his permanent residence application. The court said that the applicants can blame the advisors for their own mistakes, so his application was denied. In summary, understanding and following these rules can make your application more likely to succeed, especially for business immigration, which involves a lot of money and is very complex. Even small mistakes like not mentioning a past visa denial can ruin your application. Now remember, giving wrong information isn't just against the law, but it can also mess up your chances of immigrating. By avoiding common mistakes, getting professional help, keeping up with the rules, checking your information, and being open about any issues, you can make sure that your application is accurate and believable to the immigration department. Always remember that saying you didn't know the rule or misunderstood, it isn't usually accepted as an excuse. Being careful is key to a successful application. Would you like to become a permanent resident in Canada? Our licensed consultant at Sinca Immigration can evaluate your profile across Canada. Now get started, contact us, and we'll love to hear your story.